Okay, let's see. A little bit of housekeeping here to begin with. We're meeting today at the scheduled time to consider the prosecuting attorney nominations that came to us from the Republican Central Committee late last night. We received a letter, an official letter from Chairman Mark Fuller, explaining that pursuant to Idaho Code Section 59906, the Bonneville County Republican Central Committee has conducted interviews of applicants for nominations to replace Danny Clark as the Bonneville County Prosecuting Attorney. The Central Committee has ranked the three applicants as follows. Number 1, Alayne Bean. Number 2, Randy Neal. Number 3, Russell Spencer. He asked that he would appreciate the commission advising himself personally before we put our decision out. The difficult thing this year is we're conducting this on Zoom. So this will be for you, Spencer, also. It'll probably, the way we will proceed, we've had one candidate withdraw. So we're going to have you now, and then Alayne Bean immediately afterwards. Then we'll go into executive session to deliberate on the selection. Then we'll come out of executive session to take a vote. And that vote will be held also on Zoom. So it's going to be hard to notify the successful and the not successful candidate at different times before we release the public, because it'll be simultaneous. So I would encourage you, and will encourage Alayne to be participating on Zoom so that you can find that. Am I missing anything? Procedure. Okay, what we probably like to do is we've got half-hour blocks scheduled. Those are the maximum. So, we would anticipate approximately 20 minutes for you to, we'll start out with you kind of summing up, because a lot of information that came out last night during those interviews. I think the Republican Party did a very good job. The process seemed very fair, even-handed, just kind of let it flow just naturally, which I really appreciate. I think Chairman Fuller and the Central Committee did a really good job of that. So we've had you submit resumes because I haven't seen those before, but appreciate those. We'll kind of look through those, but we'll start out by giving you a chance. I know you had a closing statement last night, but to maybe go through and kind of sum up your thoughts, kind of a post-closing closing to open this, if that makes sense, so that you can sum up and give us any information that you don't think, every time you get out of an interview, you think, man, I wish I would have said that. This is you, man, I wish I would have said that moment. So take 5 minutes and then we'll open it up for questions from the two commissioners and myself. Then we'll offer any other opportunity for you to give any responses or anything you feel like you may have missed. So go ahead, Russell.
Thank you, Chairman Christensen. I guess if there's something that I could pick up on from last night, I understand that while the precinct committee officers were discussing the candidates, a question came up that was a little bit more concerning to me about were I to get this job, what would my tenure look like? Would they be doing this again within the next couple of years because I'd be jumping ship? And that's.
I know it does that. We apologize for that. Zoom is a good thing and it has its drawbacks. So
I'll just try to ignore it, but
okay.
That's not the case. I want to assure this committee and anybody listening in with us that if I'm successful in this appointment, I will be running here in May, and I'll be running in November, and in 2 years, I'll be running again. What I don't intend to do 4 years after that, and the reason for that is there are things that I want to be able to accomplish, and they are discrete things I want to be able to accomplish. The first thing I want to do is I want to have consistent sentencing across our office, consistent plea agreements across our office. Consistency in this way is important to me. There was a case that I was assigned when our friend John Dewey went down to Beanham County. It was a sexual offense, a statutory rape. The defendant was someone who was developmentally delayed, lived in a assisted living facility, had been sleeping with a 16-year-old girl and giving her gifts for that. He was required to do a PSC, part of the evaluations for sentencing. And on the polygraph examination, it came back that he'd been deceptive. So I looked over this case. There was mitigation here. I had a great concern about protection for the community. I couldn't judge his risk assessment because we didn't have back a straight polygraph. And so as I looked at that and I really labored over this thing, I came back and I said, he touched the victim. This has got to be a prison case. The judge, and I argued for a prison sentence. And the judge gave us a prison sentence. 6 months later, I was at a probation violation hearing for the man who turned out to be his co-defendant. He'd been sentenced earlier, and the attorney who'd been assigned to that case had decided that probation was the more appropriate recommendation there. Same developmental delay, same house, same victim, same crime, same issue with the polygraph examination. He also actually gave back a deceptive one. We could not have had two defendants who are more similarly situated than these two men. And one's in prison and the other's on probation. Justice requires, if nothing else, that we treat similarly situated people the same. And in that case, we didn't do justice. That's one of my concerns. That's one of the things I think needs to change. And so that is one of the things I want to do. There's a second thing. I want to start having grand juries again. I know we haven't had one in this county, or we haven't had them regularly, at least, for a couple decades now. But there are a lot of cases where I think we need to have them. We come back with our SIU detectives, the narcs units. And they often will kind of pocket cases and hold on to them when they have a confidential informant, because they're trying to protect the identity of the confidential informant, and that's all proper and correct. And then we go through the prelim, and it's very clear that all this defendant wants to do, and the reason we're here at prelim, is they're trying to figure out who sold them out. The grand jury proceedings are sealed. If we could take our CI cases and put them in front of a grand jury, we wouldn't have to wait the length of time before we can process these cases, and we could still protect the confidential informants. We also have sex crimes that frankly should be in front of grand jury, because again, they're sealed. Nobody wants the very worst moment of their life to be made public to everybody. We had a case where the attorney took it through a grand jury. Sorry, not through a grand jury, but through a prelim. And it was a hard prelim. And the victim didn't come out great. That just really, really, really emotional harm for this lady. And then they were approaching trial, and they learned that our recording system had not properly recorded that prelim. And now the attorney was in a terrible place. Do you take the prelim again, knowing what it cost the victim last time and knowing the victim does not want to do that again? Or do you cut a deal, knowing that this man who's done this awful thing is not going to be giving the punishment that he needs and deserves? she chose to cut the deal. And I understand that, but if we had a standing grand jury, maybe that's a question that wouldn't have had to come up. So I want to have grand juries. The third issue that I see is a lot of times we kind of get a bad rep in the press sometimes, because like we are too soft on certain cases, or we give away certain cases. There's a reason for it. Sometimes the cases aren't especially strong, and we're willing to charge cases here that might not be charged elsewhere. So they're strong enough, we have probable cause. And there is the chance that defendant would be found guilty, and they know that. But we also know there's a good chance that they wouldn't be. And so these things get pleaded down. We have a bit of an issue right now, a culture that I'd like to see changed, where it's almost like we're running a relay race with the cops, where we'll have cops come in carrying the baton, it's their case, and then hand it off to the prosecutor, and then it's no longer their case. I want to help change that culture. I've talked to detectives about this a lot, and some of the feedback I've gotten and some of the things that would help, a lot of them feel like they go out and they do the follow-up that we've requested, and then we come back and say, okay, now do this. And then we come back and say, now do this. And then come back and say, now do this. And they're like, you're dithering, you're delaying, you're dragging your heels. I'd like to put together with the detectives sort of warrant checklists that would allow us to say, you know what, to prove this kind of case, I need A, B, C, D, and E. And the detective can go out and say, all right, to prove our case, we're going to need A, B, C, D, and E. And then the warrant comes in, and I've got A, B, C, D, and E. We can charge it, we can move forward. And this isn't the kind of case that we should have any concern about falling apart down the road. We will be in the driver's seat. And that's going to be important too, if we're going to be able to do the things that I want to do with the consistency in sentencing. The truth is, you guys have my resume in front of you. I've been practicing for 12 and a half years, and I think I have an incredible breadth of experience. I began in private practice. I moved over to the Attorney General's office. I then went out to Pittsburgh and worked on the Third Circuit Court of Appeals. And I've been here for the last 2.5 years, currently serving as one of the senior deputy prosecutors. What I've done, I feel, has well prepared me for this position. But you shouldn't be choosing me because of what I have done. I hope if you choose me, it's for what I will do if put in this position. Thank you.
Okay. Go first.
Well,
Go ahead.
first, I want to thank you for putting yourself into this process. I think it's a great reflection on Bonneville County to see such talented and qualified applicants, for this position. So thank you for being willing to do this. You really answered my question, which was what you would bring to build upon the effectiveness of the office and leadership that we've had. You've answered that. So just quickly, the second big concern that I've got is the huge backlog of cases that developed over the past 2 years. Again, quickly, because I know they have answers, but how are we going to work through that and get this caught back up?
We're going to have to do it one case at a time. Now, a lot of the cases that we have are actually, we have defendants with multiple cases now. And so you take the main one first, and that probably resolves quite a few of them down the road. I think if we're strong and we come in, we're going to have to be doing probably a trial a week inside our courthouse every week for a few months. But once the defendants see, I don't think this is on the defense counsel. I think the defense recognizes where we're at in this process. Once the defendants see that we're serious about what we're doing here, that we haven't just been sitting on our laurels for the last 2 years, that we have been anxious to be able to take them to trial. It's likely that they're going to start pleading out. We actually saw something like that this last year when it looked like we were going to be back into the trial flow. I had my case in Jones in May. And then the next week we were going to be doing Wangwood, but he kind of absented himself in the middle of that process. The next month, one of our senior deputy prosecutors, Adam Garvin, had a case, a drug trafficking case. I sat second chair with him. He was in the middle of questioning the first witness when the defendant decided, never mind, I plead guilty. We had another case, Ryan Jolly, another drug trafficking case. The defendant showed up the day of trial, never mind, you were serious, I plead guilty. So I think that's kind of what we're likely to see here, but I can't guarantee it. And because I can't guarantee it, what I can guarantee is that I will stay in the courtroom too. And I will continue to prosecute cases, continue to have trials, as long as we have this backlog at least, to ensure that the rest of the attorneys in the office don't get swamped in this. Because we're not going to have great resolutions here if we don't have attorneys who can give their focus to these cases.
Thank you.
Commissioner borrowed my question. It's okay.
Don't worry, I'll make it a list.
Are you good? You talked about the civil grand jury, and it has been a long time since there's been one account. The reasons for using the grand jury mechanism were ones that I hadn't considered. My reasons for having to call for one if I had would have been different than that. But so my question is related to the budget with the backlog of cases. What do you see as the most fiscally judicial route to make sure justice is served and budgets maintained at the same time? I mean, that's the balancing act that it comes to. And the second part of that is, what does it cost us to serve grand jury?
I can't give you exact dollars or cents on what it costs at a grand jury. My understanding is sitting a standing grand jury is less expensive than calling grand juries continuously. So if we have a standing grand jury, we'd have the 1 day with the total veneer panel and voir dire. We would shrink that down to the actual grand jury. And then that grand jury ideally would be coming in once a month. And once a month, we'd have a grand jury day, the same as they do in the federal courts. The grand jury by statute, I believe, can sit up to 6 months. And so we'd allow them to come in, figure out what day works best for the foreman schedule and the rest of the grand jurors. We need to make sure we're going to have a quorum every time. And then present our cases that are grand jury type cases once a month, and do that for 6 months, call a new grand jury. I think ultimately, it's worth the expense if there is an extra expense, because of some of the things that I was identifying there. The ability to better protect our CIs, the ability to better have for these victims of heinous crimes to come forward and feel comfortable knowing that what happened to them isn't going to be broadcast everywhere.
I thought mine was a good question.
Well, it is. You know, it's actually kind of nice that the 30-minute rule isn't hard and fast. We just want to make sure we get it all here. Just from your facial expression that you seem a little concerned on that, but we want to make sure we have a thorough understanding. John asked one of the questions about the grand jury. I do remember a grand jury here. It's got to be 3 or 4 years ago. So we have had grand juries. One of the benefits of being here for as many decades as I have, remember some of those. And they are difficult, but very, very useful. But focusing on some of the things you would like to work on, like consistency of sentencing, how would you accomplish that since it's the judges that do the sentencing?
Well, I do know that we can't bind the judges. And I don't actually intend to either. One of the things that I pointed out last night is while we can't determine what a judge is going to do, we can decide what we're going to do beforehand. And if we're coming in and we're consistent every time, I believe having that kind of certainty is going to allow the judges and defense counsel also to kind of have an idea of at least where the state's going to be. I think quite often our recommendations might not carry the day, but I think they're very persuasive. I think they do come along with us. But if they don't, I'm not as concerned as if we're not consistent. Because again, the major focus here is we can't say that we're doing justice when we're the ones treating the people differently. We have 3 judges here in this courthouse at the felony level. We have other senior judges who come in and sit all the time. They're going to go ahead and sentence where they feel comfortable. I recognize that. And we might get different sentences in one courtroom to another courtroom. But I think for us to be able to stand and say that we did justice, we need to be able to come in and say, because every time we have this kind of offense, this is the range that we're in. I don't think that there's any offense that needs to be like, and this is a 2-year felony, and this is a 5-year felony. But I do think there's some wisdom in having, this is kind of a 2 to 5 year, and this is more of a 4 to 8 year. And that's what I'd like to see happen. Now, I imagine there'll be, but I think if people take a moment to kind of step back and think about it, I feel bad for some of the defense attorneys. If you have, say, like a drug delivery case, well, you could have probation, or you could have life, or you could have anywhere in between. And as a defense attorney, you're talking to your defendant, and you're explaining, you know, this is what's going to be in front of you. These are the kind of the options. And they hear probation, and then we've kind of worked through the case a little bit. Discoveries come through. They've seen everything. They kind of have a better understanding what's going on. They come back to the defendant and be like, I've worked out an amazing deal. I got you 2 to 5 years. What defendant's going to be excited about that? Like, you're a lousy attorney. You said probation. Now I'm going to prison. But if they can know that we're going to be coming in and like, this is a 2 to 5 year kind of crime, and they can come to the defendant and say, like, it's going to be somewhere between 2 and 5 years. And then they get to come back a couple months later after they've done all the negotiations, say, we got you 2 years. Now they're a phenomenal attorney. So it helps them out. I actually saw this when I was at the Attorney General's office. We see how things are done everywhere in the state. And counties that had, they called them a price book. So there's these sentencing guidelines that are internal to the prosecutor's offices. Counties that have those kind of price books tended to have easier times working through things in the long run with defendants and with the defense, because everybody had a good idea going in what things were going to look like when they came back out the other side.
Good, and I think that kind of answers my next question. Which is different, all the same process. Budget related. From the commissioner standpoint, ours is a budgetary. Each elected official is basically independent elected office. But there needs to be an understanding of the working relationship between the prosecutor and the commissioner's office on what we can do, because there are some statutory limitations on what we can collect. Basically, the Justice Fund has a cap. We're competing with the Sheriff's Office, some of the court clerks, things like that, that we have to balance each year. You know, are you willing to work in that arena? Because you said like grand jury expenses are worth it. You know, this will be more of a yes and no. But for example, it would be nice if we all had all the budget. I mean, we deal with that in the sheriff's budget all the time. You know, he'd love to have 10 more officers out there because he can't keep up, but has to learn how to work within the constraints of his own budget to make sure that and balance, to make sure prosecutor's office, public defender, everybody is well funded in this pocket of money that we have. Are you willing to work with the commissioners to do that?
Yes.
Okay. The other, this was one comment that I picked up on last night when we were talking about, seems like, you know, the life of prosecuting attorneys, staff was short. We worked real hard to get that up, you know, get the pay more attractive. One thing that concerned me, and maybe give you a chance to address it, is when you talk like, you know, the prosecutor's office is a training ground for attorneys to go out into the private sector, which, you know, we've tried to keep them as long as we can because you get more value out of more experienced attorneys. They may cost you a little more, but you keep turning those over, you know. There's been a real good process set in place in the current prosecutor's office with Danny Clark on how to move people up, you know, and then hopefully get them to where they can keep them because experience matters. Maybe you can put my mind at ease a little bit that there's a training ground.
No, that's not what I had intended to convey at all. It was just a recognition that, generally speaking, most people went to the prosecutor's office for about 3 to 5 years, and then they would go off into private practice with the law firm. It's about that time frame that your value in a law firm is kind of at its maximum. You've had the opportunity to be in trial, be in the courts, do that kind of litigation. But you're not so seasoned that you have your way of doing things necessarily. So you're a bit more malleable. And there's also time for you to be able to be placed on a partner track. And so it's better for the person there too. The concern that I had is that I have senior attorneys that I work with that I see every day. I have a friend who left a prosecutor's office to go and get civil experience with the intent to be able to go and do private practice. We get paid more than a living wage. We get paid quite well, I think, especially when you add in all the different benefits, the Percy, and having that kind of consistency. Again, I began in private practice. And so having had that small business kind of experience, I know the fear, the terror you feel when it's like your whole future is sitting on the edge of a knife blade, and a single breath is going to knock you over into financial ruin and just cripple you and your family forever. You never have to feel that when you're in public service. So there's a huge benefit there because you do have that kind of foundation you can build on and that stuff you can rely on. But it comes with trade-offs. And there are some attorneys who balance it differently than I do. Maybe because they haven't had the experience of being out in private practice before. What I'm trying to do, and what I was trying to convey there, is I want to ensure that my senior attorneys have a way to continue to grow in the office. So the question, the comment came up regarding what would you do with the arrangement we've had with Nelson Hall? And the thing is, I would review it, but I can envision, as our county continues to expand, that allowing that the budget will also continue to expand. our office is going to need to continue to expand too. And I think about people that we had in the office, incredible attorneys like John Dewey. I always wonder if we had had some sort of in-house civil position, would he still be there with us? He was an incredible resource to have. He's actually going to be the lead prosecutor for our Waynewood case when we come back to it. But that's because he's willing to come back and help us with it. There's nothing requiring him to do something like that. That's just because he is who he is. What if we could have him still in the office every day? These issues come up and these kind of sex crimes and stuff where John has incredible experience. We have come up with domestic violence cases. The trial I took was a case where my witness didn't show up. And we had to go ahead and go to trial without her. But I was able to do that and prepared to do that because John, a few months earlier, had given me a training and the rest of the attorneys a training on how to put in the testimony of an unavailable witness who'd been there before. We hurt when we lose those kind of assets. So my intention isn't to just send people off. My intention is to give them some, if you're not continuing to grow in your career, if you're starting to stagnate, nobody wants to be in that kind of position. But if we can have something like that that allows these senior attorneys to continue to grow, they'll also be able to continue to help the office. That was my goal.
Anything else?
No, I just wanted to thank you for the effort and time. But how well prepared you were last night to make the presentation and actually being able to be there and participate and watch, that was an opportunity to learn a great deal of what we've been asking questions about today. So like this process from your side, maybe not quite so much fun, but I appreciate all the hard work and effort that you put into that, besides what you put into your job already. So thanks.
And I'll echo that because I've been involved in a few more of these than these two have. We've, over the course of my career, selected 10 different elected officials replacements through this process. And I think what time has shown that we have a very good slate of elected officials. And you know, it is a tough deal to put yourself out on the line. So we appreciate that. Thank you. We will now go into recess. So we'll recess on the screen for everybody while we switch over probably 2 or 3 minutes for our next interview. Okay.
Thank you.
Thanks.
Thank you.
Taking input over this, turn our volume down, we won't get that obnoxious.
Well, no, that's not fair, man. You got to make sure you have
We
the
just
whole time.
ignore it.
Thanks. There's other reasons to take recess for us.
I think we leave it
Okay,
where she's.
all right. I don't hear it anymore because it goes all day, every conference that we're in.
Kayla, could we come out of recess? Just curious how many. That's it. It's an inside joke. Okay, second interview of the day is Alayne Bean. I don't know how much of a process you listened to when we started, so I'll repeat
None.
everything so there's a clear understanding. We received an official submission from Chairman Fuller. I'll go ahead and read that again because there's several new people online. Commissioner Christensen, pursuant to Idaho Code, Section 59906, the Bonneville County Republican Central Committee has conducted interviews of applicants for nominations to replace Danny Clark as Bonneville County Prosecuting Attorney. He has ranked the three applicants as follows: Alayne Bean, Randy Neal, Russell Spencer. I would appreciate the commission advising myself personally of who is selected so that the information can be conveyed to the Central Committee. In these days of Zoom meetings, it's going to be difficult to, the process we'll go through is we'll finish up the interviews. We'll go into executive session to deliberate, come out of executive session back into open session to take our vote, make our selection. So it's going to be difficult to inform both the applicants and Chairman Fuller ahead of time, because it'll be streamed live. So hopefully you'll understand that. You'll make sure to be logged in.
Certainly.
With that. Again, we appreciate the Republican Central Committee and Chairman Fuller's efforts and work with the candidates that are put in here, because it does take a great deal of effort and time. Kind of expose yourself to a large group of people, which is a tough thing to do. So we do appreciate all those efforts. I listened in last night. These two were in attendance in person, so we've heard your speech, your interview, your questions and answers. And so we'd like to, within approximately the next 30 minutes or so, it doesn't take that long, that's fine. It just depends on how long your answers are. We'd like to first give you the opportunity to elaborate. You get to the end of any interview, man, I wish I would have said this, or wish I would have said that, or this differently. I'm sure it's the same way at trial. So we'll give you an opportunity to begin with. We'll call that your closing statement, rebuttal, or addition. I don't know what the legal term of that is. For just a few minutes, if you want to clarify anything, and then we'll have the commissioners ask any questions that may have come up on your presentation or your resume. Then we'll just go from there.
Okay, thank you. Is the procedure to stand? I've never appeared in front of you.
We're not judges. People will have to stand for Danny Clark now, but it's not us.
Very true. Yep, we're already doing it. Thank you. I guess if I had a little bit more to add to my experience that goes towards the management aspect of the prosecutor's office, because at the end of the day, the county here is one of the largest employers in the area. And so there's a business aspect to that, and you manage people through that. And the prosecutor's office is a division of that. And so I wanted to talk a little bit about my experience in that, and also what I've been doing as the chief deputy to foster a good office. First of all, I got involved in the legal system in the year 2000. I wasn't able to go to law school at that time, but still had a true love for the law and an interest in that. And so I started working as a paralegal, and I did uncontested divorces and bankruptcies. Got to know a lot of really good people and seeing people at the worst times of their life. When people come to an attorney, when people are involved in the prosecutor's office, it's not a happy time. And very much developed relationships with the people that I represented as a paralegal and interacted with, and tried to learn to build relationships, because at the end of the day, relationships are what matter in your workplace, in your daily lives. And so I saw that at an early time. I actually was very successful as a paralegal and developed a questionnaire for bankruptcy clients to fill out. And that questionnaire was requested from me by other attorneys in town. So I do a high quality of work with whatever I'm doing. I'm very good at organizing and processing information. And that's just, thank you to my mom and dad, I have that talent. But that's something that I've been able to capitalize on. I took a little break from being a paralegal for a while and actually ran my parents' business. I brought their business from Utah up to Idaho Falls after they passed away, and then had the opportunity to be a CEO and company president of a forms design business, and had to work with multiple suppliers and do the taxes and be accountable to shareholders. And then again, those organizing and management skills came into play. In fact, my CPA, who is a former prosecutor from years ago, wrote me a letter of recommendation for law school after observing my work as a company president. I retired, that company is still going, but I retired from that to be an office manager and paralegal at a local firm here in town, and managed other paralegals, trained other paralegals, and then also kept things running for two very busy attorneys who had the public defender contract for Bonneville County. It became very evident that I still wanted to go to law school, and that was a passion of mine. So in 2012, I did go to the University of Idaho. I was the recipient of their highest scholarship for academics. It's the full scholarship, and it paid not only my full tuition, but a $10,000 stipend. So I'm very blessed to have come out of law school with not very much debt because of the generosity of the University of Idaho and the Fultz family. During that time, I also decided, because I came and did 120 hours of pro bono work for Bonneville County when Bruce Pickett was the prosecutor. I did that pro bono time, and that's where I developed a love for prosecution and decided that's who I am, that's what I want to be when I grow up, so to speak. And came back, changed my schedule in classes to focus on criminal law, did an externship and internship with the Latah County prosecutors that lasted a year and a half, where I was an extern for one semester and a paid legal intern practicing under a limited license for a full calendar year for them. That's another reason, because it was paid, that I came out with not so much law school debt. During that time, I got to see prosecution, but I got to see a different officer's perspective in a different type of county, more rural than Bonneville County. But they had some very good ideas that I want to incorporate into Bonneville County, because I think we can't say, well, our county's big, so we give less customer service. We have to give good customer service. One of the things that was under my responsibility was to go to misdemeanor arraignments and felony initial appearances and argue for bond in every case. And we don't do that in our office right now. We're a little, we've tried to see if we could work it in personnel wise, and I think I can do that. I think I can get a rotation where we are going in front of our magistrates when people are coming up on felony cases and get better bonds, because when you read out in the paper, people in our community are really upset about two things: bonds and writers. And I'm also working, this is a spoiler, I guess, but also that's one of the concerns I have, and I've met with the Department of Corrections chair and talked to him specifically about the fact that from one year to the next, the outcomes are now worse in writers, and they are not a good option. Our community has keyed in on that and is very upset about that. But back to Latah County. So there's ideas I have from being there under a different leadership. I came immediately after graduation, I think 10 days to move and start my job here. Danny hired me in 2014. They kept the position open for me from January, basically when he took office, to May of when I started, and all the prosecutors there worked extra to wait for me, and I'm so grateful because this has been the best job I could have ever hoped to have. From there, I started first as a legal intern because I didn't have my law license yet. I had to study and take the bar while I was working, passed the bar, and became an attorney in October. Since then, I have been promoted 8 times. And I started at the bottom. I don't mean to disparage the juvenile cases, but in kind of the level of things, that's where you start. That's where you earn your chops in getting a lot of cases all at once, and worked my way steadily up to a full felony caseload, and now handling the most serious crimes as the chief deputy. I mentioned last night that in 2020, when John Dewey retired to other things in Bingham County, Danny had a choice to make, and he had already been giving me additional managerial duties as a senior deputy, but he had some very qualified people in front of him. And when it came down to it, he chose me. And I don't want to say he chose me and then that makes this automatic. It's not. Historically, it has happened, but it's not automatic. But I think in the time that I have been chief deputy, the office has flourished. Our attorneys we finally got a 1-to-1 attorney to staff ratio through my moving names around and juggling positions and looking at that. Mr. Clark thought that that could never happen, and I did it. We've also increased attorney trainings. That was one of the focuses that I had as well. And we started with Mr. Muir being the attorney trainer, and now it's Adam Garvin who is doing the attorney trainings. We need to be even better and more consistent at that, because as our office has success or not, it's reflected on the whole office. And so we need to make sure that our attorneys are consistent, well-trained. And I can tell you right now, every individual we have in there cares about their job and tries their best. We need to just provide more structure and skills so that they can fulfill their maximum potential. The climate in our office is better. Like a business, I inherited a little bit of drama within staff issues and things like that. I worked throughout 2021 to train on each month on a quality that makes our office run smoothly and is important in a prosecutor's office. We talked about diligence. We talked about honesty. We talked about the need for confidentiality. We talked about teamwork. We talked about our accountability to the community. And after doing that, I can say that, and I verified that with Ms. Millhouse, who has the pulse on everything in our office, that the office is running so smoothly and assistant issues there's just no infighting or anything like that. It is a very wonderful work environment for everyone. One of the things I do focus on extremely is teamwork. We have situations where someone is ill, someone has happy family things that happen and babies being born. And everyone is just so willing to pitch in and help that person be successful. I guess in a little bit of closing, I will say I've already been assuming these duties as Danny has been busy, things that have taken him out of the office as he's pursued his career aspirations. And so I have taken on more of the duties that have been in the prosecutor's office for the last year and really longer than that. I am the go-to. I am technically the on-call prosecutor 24/7 for major crimes and law enforcement leadership. They know they can call me literally any time of day. I talked about a case last night where they called me. It was 2 o'clock in the morning. I got a call from a detective, and he was dealing with the case where the one man was trying to pull the other man out of his vehicle, and then the man in the vehicle shot and killed the other man. I get a call at 2 o'clock in the morning, and I have to have case law at the ready. And that was important because the statute on the Castle Doctrine says no person shall be placed in legal jeopardy of any kind whatsoever. And an arrest is legal jeopardy. And so we had to make that on the fly decision. And so I was the one to consult with them and give them what the case law was so that they could follow the intent of that law while we investigated that further and made sure, are we going to file a case or not? Because we don't want to file a case if we shouldn't file a case. So because I've been assuming the duties, I think I can guarantee you the smoothest transition from Danny leaving to the office becoming under new leadership. I think I have that capability because I've already been doing it. And I have the respect of my peers. I have the respect of the staff. And this would just be pretty much life as normal in the Bonneville County Prosecutor's Office, which is a benefit to you, I would hope. So, thank you.
It is. Go ahead, Commissioner Reed.
Okay. Well, first, let me say thank you for being willing to put yourself up here to this. I mentioned before, I think it's a great reflection on Bonneville County and the prosecutor's office to see such qualified, talented people willing to put themselves out there in the public and take on this position, and it's such a critical position. So thank you for being willing to do that. I guess I would just ask, what concerns you the most, or what do you see as the greatest challenge in the future going forward in the Bonneville County Prosecutor's Office?
We have had an increase in crime. I don't know how related that is to issues with COVID, because I think that has affected things. I also think the population increase is affecting that. So I think we need to just be diligent in keeping the crime level down with appropriate sentencing recommendations and plea agreements within Bonneville County. As I said, the rider program is really coming under scrutiny. People don't like it. And I think if there's one complaint that our citizens have about our office or the court system in general, it's the overutilization of the rider program. I don't know that that all falls on our office. Sometimes you have a prosecutor recommending prison and a public defender recommending probation, and the rider program seems like a nice way to split the baby. The problem with that is it's the least successful option for most criminal defendants when you look at recidivism. So it isn't splitting the baby, it's actually leading to a pretty poor result for repeat offenders.
Thank you.
Can I follow up on part of that question?
Sure.
Before we move on? Explain the rider program. You have some
Okay.
individuals who are listening to this, and what type of an option it is, and why you don't think it's successful.
Well, first of all, from the comments on the News and Post East Idaho News and Post Register, I thought everyone knew what the rider program was. But the rider program is actually, it's officially a retained jurisdiction. So what the judge does is say, I'm going to keep jurisdiction over this case for up to 365 days. And then in that time, I'm going to see how you do. And then I will make my decision on whether you should be placed on probation or go to prison. And so at the end, so someone goes to, let's say it's a male, they go up to the Cottonwood facility for IDOC, and they enter into a program of classes and treatment. They address drug things. They have a sex offender program, various treatments. They have to get up when they're told when to get up, eat when they're supposed to eat what they're supposed to eat, without breaking any of those rules, just like a prison setting. But after they complete their program classes, then they, the facility prepares a report that comes back to the judge, prosecutor, and defense attorney, making a recommendation to any given individual. Should they be placed on probation at that time, or should they be placed in a prison facility because they haven't done a very good job? It's percentage-wise on the latest numbers from the Department of Corrections. They break things down into male and female, low risk, medium risk, and high risk to reoffend on both. So there's 6 categories, 3 categories for males, 3 categories for females. On the males, it's the least successful option of probation, rider, prison of all categories, low risk, medium risk, high risk to reoffend. On the female population, it is the actually the best option for low risk to reoffend females. It is an equivalent option for medium risk to reoffend. It's almost identical percentages, 33, 33, 34, between probation, rider, prison. On high risk females, it's the least successful. So out of those 6 categories of individuals, it's the least successful on 4 of those categories of individuals. So we need to be, It doesn't mean the rider program fails, absolutely, but that knowledge is power. We need to be recommending on low risk to reoffend females more than males because of the success rate. And certainly I think what gets the community agitated is when there's a victim crime and they're getting a rider, so someone victimized either property, and they're certainly looking at violent crimes as they should never have a rider. So that's part of that. What was the last part of your question?
No, that
Did
was the question.
Okay.
So basically, your solution to that is to study, and it's on the recommending side of things, to recommend a little harsher if somebody you don't think is going to be successful, then you evaluate, you do that, versus, I mean, is it in your mind the role of the prosecutor to make a strong recommendation if you don't feel the rider program's the best? Is that summarized?
Definitely. If we do not feel that is appropriate, we should be arguing for something different, either probation or prison. If we think that someone can be successful with all the evidence, when a prosecutor and a defense attorney are making their recommendations, they get a thick packet called a pre-sentence investigation. And so they actually do have tons of information about a person's history. So, I mean, that information could lead us to have originally thought a rider and think probation is better. Our job is definitely to make recommendations. Judges make decisions. Our job in making recommendations is also to educate the judge about law and about issues. And I think now that we have the numbers from the rider program that have just been released, we need to be better about educating our judges about who can be successful in that program and who can't. Can I give you an example of why it's a little bit overutilized? I had someone where we recommended prison, previous history, he was on parole from another crime. That person should never have gotten a rider. In his prison experience, he had 16 disciplinary actions in prison. So when he's supposed to be on his best behavior and highly monitored, 16 violations. He comes out and reoffends and then gets a rider in spite of our recommendation. While on a rider, he got 14 disciplinary actions over the course of 4 months of his 6-month program. That's a 2/3 fail. I recommended that the court relinquish jurisdiction and he went and go to prison. He got probation, he got placed on probation again. The other part to the rider program is if we had confidence that when someone failed their rider, which that is essentially a fail, that the Department of Corrections would recognize that fail and recommend that the court relinquish jurisdiction, but they did not. They recommended that he be placed on probation with a 2 out of 3 fail in a, percentage wise. And then, the courts give a lot of deference to the people writing those reports. And so he's back on probation. I hope he does well. I hope for everyone he does well.
Okay, sorry to jump over you, but I understand a lot of these, but I don't think the public really has, any education. I think helps. So go ahead, Mr. Walker.
All right, thank you. So right now there's a tremendous backlog of cases because the courts are not running courts because of COVID. How do you plan to deal with that backlog, with budget constraints and justice for victims?
The backlog is almost a fiction. So first of all, Bonneville County, I actually just ran into Judge Watkins, who's our administrative judge, and we were talking about this backlog, and he indicated that Bonneville County is one of the best counties in resolving cases during COVID. So statewide, there's probably a backlog, but the reason I say it's a fiction is there's no deadline for a defendant to take a deal. So we resolve most of our cases by plea agreement. If it doesn't resolve by plea agreement and needs to go to trial, that's fine. The people who are going to go to trial and always intended to go to trial are going to go to trial. The people who intend to resolve their case by a plea agreement, but they can do it today and they might get more strict community guidelines, they might get a rider, they might get prison, have zero incentive to enter into that agreement today. Once trials resume again, the people who are going to go enter into a plea agreement are going to do it because they're facing a trial deadline. So there is a lot of cases. Our docket is busy, week to week, but that busyness is not destined to continue after the COVID restrictions are lifted.
I really don't have an in-depth understanding of where you play in all of the specialty courts. What's your feeling about those, their effectiveness?
Our specialty courts for people that meet criteria. So they have to have a certain risk to reoffend measured by a level of service index, LSI. So that scores their risk to reoffend, goes from 0 to 54. They have a minimum, I think it's around 21 or 23, depending on if you're a male or female. So they have to meet that. They also have to have a certain level of substance abuse needs. These are geared to substance abuse problems and criminal conduct driven by substance abuse. And then we have the Wood Court, which also has a mental health component. So they have to have a specific diagnosis that meets the criteria for Wood Court. So in the people that meet the criteria to be in those courts are the most successful option. I've been on every one of the specialty courts, including all the juvenile ones, except for mental health court. The reason they're successful is they have a high level of accountability. A person starts that program with weekly visits with the judge. And as they demonstrate their ability and to remain compliant in the community and adhere to the rules of probation, and they have not even substance issues, they will forgive relapses if you're honest about it. But as they measure that compliance and a person earns their way to the next level, then they have reduced community supervision, reduced appearances in front of the judge. But I think that meeting with the judge, having a team of people behind them is literally a key to success, because that's what we're having the good results, people progressing. It's not a perfect program. There will be people who fail out of it, but we literally have the best success rate in that program. I say, if they meet criteria, sometimes people like fudge on their level of addiction. They might, because it's a self-report. And so if we don't truly know someone's level of addiction, we can't truly address where they are in that. And that could be a reason that someone could be not successful in the program. But specialty courts, we get the biggest bang for our buck on those when you're looking at preventing future crime and helping people.
Thanks. You've done a pretty good job answering a lot of the questions that pop up as we go along. Kayla, if you're listening, could you bring us in a form for going into executive session while I ask my question? We have an adversarial system, prosecution, public defense. Sometimes that gets a little tense. What's your ideas for sometimes a strained relationship from defense office and how to keep that flowing?
I truly believe that I am the best person to address that issue. I have longstanding relationships with many of the public defenders going back decades. They know me, and they know that I am a person who will be proactive in reaching out to them when I see a case issue that they should know about. I think there's actually a court filing by one of the public defenders who said Alayne Bean was the only one who gave me the information I needed without me having to ask. I have credibility with those offices. I have credibility with the defense bar around town, not our public defenders. I would like to have more of a process with the leaders of those offices and actually get someone from the defense bar to be a representative for the private attorneys where we can talk about issues. I know we had an issue come up and it was a big issue of a discovery issue. And it wasn't just the public defenders, the private attorneys were voicing their concerns. And at that time, this has been 2.5 years ago, at that time, I thought we probably also need a representative from the private bar where we can talk these issues out, open door policy, talk about it on the phone first, rather than filing paper on it first. Maintain those good relationships and respect, because at the end of the day, with the public defenders, especially, we're all county employees. We need to get along. We need to be respectful of each other. We need to be collegial with each other. And we also need to be honest with each other and have that degree of trust. And so if there's any way that I can improve that or maintain that, because I think as we sit today, things are pretty good. But I'm always about improving. Anything I can do to make it better.
In closing, we appreciate again your willingness to participate in this. We appreciate the Republican Central Committee and their leadership for how well this process was handled. I guess you're aware that there's only two because Randy Neal had withdrawn after last night's meeting. And if Danny Clark is someplace out there in the Zoomosphere, I want to thank him for how well we've worked together over the time that we've served with him. He's been an excellent prosecutor. And no, I still won't stand up when he comes into the room. But and I say that now because I have a family funeral to go to, and we'll miss his court, whatever it is.
His adieu.
Okay. His adieu. It's more like a funeral. Roast. Yeah, it'll probably turn into a roast. So at this point, thank you. We'll entertain a motion. And just so those who are waiting online, we'll go into executive session. I anticipate coming back out about 10:30. We won't do it earlier than that. If we'll deliberate, and then the action we take will go back into session, out of executive session, take the vote, and then we'll adjourn. But just so if anybody's waiting, wanting to come back, it won't be any earlier than 10:30, and maybe a little later if we have a lot more to discuss. But
So, Mr. Chairman, with that, I would move that we go into executive session under Idaho Code 74-206A.
okay,
I'd second that motion.
roll call vote. Commissioner Reed,
Aye.
Commissioner Walker,
Aye.
Commissioner Christensen votes aye. We'll now go into executive session. Kayla. Thank you.
Thank you.
Okay, we're coming out of executive session. We have a couple of the applicants waiting outside. They're going to come in. So one thing I forgot.
I think the 24th is his investiture.
This is it. Let's see, I think it was 9 o'clock in the morning on the 24th. Okay, that's when the successful candidate will be sworn in. So this appointment will be made. You won't take the office immediately. We have to do the burial of Danny Clark. Have somebody raised from the ashes. So I'm guessing Danny's on there. Okay, we're now out of executive session. The floor is open for a motion and or discussion and a vote on the appointment of a replacement candidate as submitted by the Republican Central Committee to fill the vacancy, upcoming vacancy in the prosecutor's office.
Okay, then, with chair's permission, first like to thank our applicants and motion consistency with the recommendation of the Republican Committee and the discussions that we've had. That Alayne Bean be appointed prosecutor for Bonneville County.
I'll second that. Okay, I can ask you if you have a second or another thought. Okay. Got nothing to discuss on it, so floor is open for a vote. Commissioner Reed. Aye. Commissioner Walker.
Aye.
And Commissioner Christensen, I vote aye. So you will be the selected replacement to be sworn in. I think the way we timed this is you'll be sworn in. Danny retires, resigns, doesn't like the word retirement. At 9 o'clock, you'll be sworn in at 9:01. So that will be done here. Okay?
Okay.
Thank you both.
Thank you.
Yes, thank you both. Okay, we stand adjourned. Thank you for everybody for your participation both online and